to reserve 5 minutes or something like that for rebuttal?
5 minutes, yes, Your Honor. Thank you. Sorry,
Okay.
I kept disappearing on you there. This is an attorney's fees appeal in which the appellees as counter plaintiffs below had been awarded $114,600, I think is the exact amount in attorney's fees for count 6 of the supplement to their counterclaim.
And you have a problem with that because count 6 doesn't speak as a derivative action. It speaks as a declaratory judgment action, and you think therefore fees do not lie. Is that correct?
And that is part of our argument, Your Honor.
But isn't the whole lawsuit in the nature of a derivative action? And anyone who would read this lawsuit would know that obviously the declaratory judgment action is clearly based on this derivative action. I mean, wouldn't the parties have been on notice by virtue of reading this complaint?
Well, Your Honor, I think the parties would certainly be confused about that by reading this complaint, because if you read count 3, count 4, and count 5 of the counter plaintiff's complaint, each one of those counts specifically identifies the 2017 derivative statute as the basis for that claim.
Yeah, but if you read those counts, I mean, that would be logical based on what the allegations are in those counts. Whereas this is a deck action. This is a deck action that sort of is in the context of those other counts that specifically refer to that statute. I mean, yes, you could have overpled it and said this is a deck action, it's brought pursuant to a derivative action, pursuant to the statute in question, but is that really necessary?
I think yes, it is, Your Honor. Obviously, we've already.
I had a feeling you would think it would be.
And I don't think it's over pleading. We do agree, by the way, just to get over this little small hurdle. We do agree that you can plead a derivative action in the context of a deck action. We just think they didn't do it. And to be more specific, and I'll get more to this point in a minute. To be more specific, they didn't plead the 2017 derivative action in the context of this declaratory judgment action in count 6. And I think the context matters here. I made reference to counts 3, 4, and 5. And then the other things in terms of context, Your Honor, include leading up to trial, the counter plaintiffs file a trial memo. And they have different sections in their trial memo where they discuss their derivative actions, and another section where they discuss their deck actions. And count 6 is clearly in the deck action category. So in the pleading, it's a deck action. In the trial memo leading up to trial, it's a deck action. And then the trial court makes his rules for them on count 6. And makes rulings on the other counts as well. And the trial court regards it as a deck action. And so I'm referring, when I refer to the final judgment, the substantive final judgment I'm referring to, page 142 of the final judgment summarizes counts 3, 4, and 5 as the derivative actions, and then goes to count 6 for declaratory relief. And then jumping ahead in the final judgment, there's an analysis under the derivative action of counts 3, 4, and 5 on page 149 of the record, but not count 6 because that was pled as a declaratory judgment action. And then later the court addresses count 6 as a declaratory judgment action. So I think consistently, all of the parties, it was pled as a deck action. It was in the context of other derivative actions, so there's an inconsistency there. And then the court ruled on it as a deck action. And then, so part of that is about whether we had a proper notice of a claim for attorney's fees as to count 6. And again, the comparison to counts 3, 4, and 5 all have a very clear claim for attorney's fees in the wherefore clause of that count. The deck action that is count 6 has no claim for attorney's fees in that wherefore clause, and the claim for attorney's fees that was discussed in the post-trial fees motions is in the reply, and it's a generic claim for fees in the reply. And our question, and I think this is a viable question, is why are we, as the counter defendants, supposed to recognize that as a derivative claim with the possibility for fees when apparently the counter plaintiffs did not? They did not plead it as such and did not try it as such, and the trial court did not regard it as such in his ruling, because the reclassification of it as a derivative action only happened post final judgment. So our concern there with the notice is that all of those facts and circumstances contributed to us not recognizing that claim the generic claim in a reply as being our notice that there's a claim for fees in this count that doesn't appear to have any apparent basis for fees in that count. I would acknowledge, for example, that if they had pled count 6 as a derivative action under the statute and made reference to that, but for some reason omitted their claim for attorney's fees, and then they do the generic reply, I would agree that the generic claim to the reply would then attach back because there's an apparent basis for fees that has been pled. Here, that didn't happen. So that's basically the notice question. And I understand your point, Your Honor, that ultimately the trial court, months after trial, by the way, but months after trial, determined that it was a claim that was derivative in nature. But we shouldn't be held to that where the counter plaintiffs and the trial judge and the pleading itself didn't lead us to believe that, and there was no apparent basis for fees in count 6 as pled. Really, theoretically there are 3 things you ought to do for a fees claim. One is you need to plead a theory that has a cause of action with a basis for attorney's fees. Second, you have to give notice of that claim for fees. And third, you have to make a motion, Rule 1.525 motion, that is at least consistent with and not inconsistent with those theories. None of that happened here. So what we have is that the counter plaintiffs were awarded attorney's fees for a 2017 derivative action claim that was not pled, and I'll get back to that in more detail in a minute.
But the statute itself was pled. I mean, the question was, which was the correct year? When did the cause of action accrue?
I'm sorry, Your Honor.
No, it's okay. Finish your thought. What were you going to say?
You said the statute itself was pled, and I didn't mean to interrupt you. I got ahead of myself, but we don't believe the statute itself was pled. The statute
I'm sorry,
itself,
in the motion for fees.
Oh, yes.
The statute was referenced as the 2020 statute.
The 2020 statute, yes, Your Honor.
Yeah, the 2020 statute. And the court, I guess, determined on the motion for reconsideration of that the cause of action really accrued in 2017, so applied that statute. Right?
Right, Your Honor. And I think that raises other problems. I mean, we have a circumstance here where we're, by that point, we're like 6 months after the final judgment. And ordinarily, someone pleads their complaint or in this case, a counterclaim, and the basis of a count like a count 6 is known before trial. Here we're 6 months after the final judgment, and they're literally changing their minds as to what the basis for their count 6 is.
Well, I mean, that perhaps, but they're claiming it, the basis of it is a statute. The question is which applicable year, right?
Yes, but I think it's important not to downplay that the statutory scheme changed. And I think that when they made their Rule 1.525 motion, which, as the court knows, has to be made within 30 days of the final judgment, and they made that timely. When they made that Rule 1.525 motion, they committed to the fact that is our claim was a claim under the 2020 derivative statute. And they couldn't have made that Rule 1.525 motion if they didn't contend that their count 6 was a claim under the 2020 derivative statute. And then they were allowed to change their minds. And as I say, that we're talking about 6 months or so after the final judgment, they're literally changing the statutory basis for their count 6 claim. And part of that was available to them, ironically, as we pointed out in our brief, by the fact that they were not specific in their complaint, in their counterclaim. And it's not just that they're reclassifying it. Bear in mind that the 2017 derivative statute under which they were ultimately awarded fees had pleading requirements, and they did not meet them. We did not recognize that they didn't meet them because they didn't identify that that was a claim under the 2017 derivative statute. And so we didn't move to dismiss or anything like that. But ultimately, by changing the basis for their fees, they also changed the basis for their count 6, and they changed it to a basis that they never pled. And so there's a kind of a circular thing going on, and a rewriting of history, and an after the fact changes in position that put our client at a very bad disadvantage with regard to the fees claim, because how could we have known that was a claim under the 2017 version of the derivative statute when the 3 counts leading up to it were pled as that, not just by identifying as such, but by pleading in conformity with those pleading requirements, and count 6 is not. So it's an after the fact switch in grounds that effectively switched the cause of action as well. And that put us in a severe disadvantage that allowed them, through their flexibility by not pleading it specifically in the first place, allowed them the flexibility to change their minds as to what their fees claim is based on. Did that address your question, Your Honor?
Yes, thank you.
And we believe it's an error of law. The switch in grounds, we believe to be an error of law, where the court knew that the count 6 was first pled as a DEC action. It was decided as a DEC action. The court then decided that no fees, and this goes to the point of the 2 derivative statutes are very different. The court then goes through the analysis that no fees are awardable under the 2020 version. And then the counter plaintiffs change their mind and go in a different direction. Whereas if they clearly pled count 6 under the 2020 version in the first place, they wouldn't have had that flexibility to change the Rule 1.525 motion or change the basis of their underlying cause of action. We cited, one of the cases we cited is the Baggy Bunny case, which was about changing Rule 1.525 grounds. And in that case, it was changing from one proposal of settlement to another. And ours is a little bit different. I think we're similar to Baggy Bunny in that respect, that this shouldn't be a change that is allowed. Ours has that additional element that I've been addressing, which is that ours goes back and retroactively changes the underlying cause of action. Baggy Bunny didn't have that because Baggy Bunny was about proposals for settlement. So we have this, unusual evolution of count 6 that paved the way for them changing their minds, and we would contend they changed their minds twice after the final judgment. First, they win on a DEC action, and then they change their minds and say, well, we want fees as a derivative action. But they were very specific, and I know one of the arguments that was made in the briefs by the appellees is that they didn't have to be specific. Well, we don't have to argue. We don't have to deal with that point here. That's hypothetical because they were specific. In this instance, they were very clear in their Rule 1.525 motion, and then reaffirmed that in a supplemental memorandum in support of the Rule 1.525 motion, that their claim was under the 2020 statute. And so what the trial court did knowingly is the trial court knew that they made claim under one, knew that there were no fees.
You're at 15 minutes, Mr. Wallace, just so you know.
Okay.
It's your time. You can do whatever you want to with it.
I'll just wrap up. I'll be happy to address any questions at this point or just save my time for rebuttal. So I'll save my time for rebuttal. Thank
All
you.
right, you'll have 5 minutes when we get back.
Thank you.
Mr. Garcia, I'm
Please
sure you don't agree with most of what you've heard, so tell us about it.
Okay. May it please the court, Martin Garcia from Garcia Dell, and Dana Watts represents one of the other counterclaimants, appellees in this case. He has deferred his time to me. He agreed not to appear, not to participate, but I do believe he's listening in as well, just so the court is aware. And he represents Jacqueline Russell. I represent two of the shareholders as the briefs lay out and as the final judgment and ultimately the amended interim award point out. My clients had 20% of the interest of CPI, as we call conservatory properties. Jacqueline Russell at 10% as trustee, and Danielle Gladding, who is not one of the appellants in this case, but is actually the majority shareholder by virtue of transfers and gifts from her mother, Joanne DeRosiers, of her shares of CPI, and her own 10% interest that she had originally. And to
Mr.
understand
Garcia,
how it's
perhaps I
evolved-
can help you along here,
Sure.
because as I was getting ready for this one, I had a problem that maybe I'm invoking into your case, and if so, just tell me. But trying to go through the purposes after reading Stockman and Caulfield about putting notice. The rules for pleading, Rule 1.190, has certain things about supplemental pleading, and the other rule, 1.110, talks about claims for relief in subparagraph B. Affirmative defenses appear in subparagraph D. The reply here is a reply to an affirmative defense, which is an affirmative defense to an affirmative defense. And buried at the end of it, if you will, is a so-called notice to amend a supplemental pleading. I didn't find a motion or order under the rules, which is 1.190D. Upon motion, you may amend and serve a supplemental pleading and I guess amend it. So how can you put an attorney fee there in that document? I kept looking, was there a case that says the last pleading of any type, whatever filed, is sufficient? And so my first thing is, do we have compliance with Stockman in terms of putting it in a pleading rather than in a reply to an affirmative defense, as the rules separate affirmative defenses from pleadings? And I couldn't jump over that hurdle, so I figured since I had a captive audience, I get to ask.
Well, Your Honor, the rule specifically does allow that a reply is one of the pleadings that is permitted. It's a complaint and then an answer and affirmative defenses and then a reply to that. And so that the court understands the way this evolves.
It does say that. And generally, the apply says that you're applying to the affirmative defenses, if I remember the rule. But claims for relief are found in subparagraph D. Affirmative defenses are found in subparagraph D after answer. And if you're supposed to put it in a pleading, that sounds like complaint and or answer. Stockman said you don't have to say statute or contract, but you put it someplace, because not every case is going to have a reply to an affirmative defense. And I don't know whether, this is making too much out of nothing, but I kept wondering, how did we get here?
Well, and so you understand the context of how we got here. And that is the affirmative defenses that they filed. And this is important as part of the notice issue, because what they did is after we were given leave to file our supplement to the counterclaim to add the 3 new counts. So we still had the prior counts. Okay. What they did is they answered that and then adopted all to the 3 new claims They adopted all of the old affirmative defenses that they had previously pled, which included the claims or the affirmative defenses of you didn't properly comply with the statute. Okay? You didn't give us notice. Okay? Those were all included. And that's why my reply to those was addressing those issues. So I was pleading to the issues with respect to the
So the
supplemental
reply is
complaint.
coming under 100A, where it says the opposing party must file a reply containing the avoidance.
Correct. And so what I'm putting a notice on at the time, which is a pleading, and I say, and not only did I put it at the end, I put it in the title as well.
Yes, you did. And that, so
Okay.
that subparagraph A is entitled pleadings. So that would be the germane rule for me to look at.
Correct, because it is
Okay.
a pleading that satisfies, if I had done it in some other motion somewhere,
Got it.
I agree, I wouldn't satisfy.
I just wanted to make sure I was on the same page you were.
Right, but, and I think that's important to an issue that Judge Morris was talking about, that Mr. Wallace was directing to, is the notice issue. Is these were all claims, okay, that arose out of, and if you read Judge Hayworth's original final judgment, which was exhaustive, and very detailed and kind of how we got here. But it's interesting, in that document itself, he says, and it's quoted in our brief, that we did what the corporation should have done, okay? Because a debt was being claimed against CPI, and it fluctuated. Initially, it was $756,000, and all of a sudden it goes to $1.1 million. That CPI owes this debt to Danielle Gladding, and that we took action, okay? And it was in the context of, and Judge Morris, you pointed it out, it was in the context of, we had these pre-existing claims, derivative claims, and then what did we plead? The relief being sought, and I acknowledge, I did not plead, this is an action under the derivative statute, but I don't believe I'm required to do that. What I'm required to do is give with the relief that's being sought, and not only, and I'll tie back into those affirmative defenses, because I think it's important, but if you look at what was pled, the pleading that we've set forth in our answer brief very clearly, because it says, we want the court to determine whether CPI owes any amounts to Danielle Gladding under the note payable. We didn't say that this is some personal claim to any of the shareholders, which was the same position that was being taken in counts 3, 4, and 5. And they like to make a big deal as well. We claimed derivative there, and we didn't claim derivative in this one. Well, you look at, and the cases we cited to the court indicate you don't look at the labels, you look at the relief being sought, okay? And it was clear also from the relief being sought in count 6 that we were asking this court to do exactly what Judge Hayworth did, which is on behalf of the corporation to say this debt is extinguished and this corporation no longer owns that debt. That is the quintessential derivative claim, because, and as Judge Hayworth pointed out in his amended order, that is an action that's being taken while it benefits shareholders, obviously, because any action that benefits a corporation benefits the shareholders. But this was a classic issue where the claim that was being asserted for declaratory relief, and it was distinguished from the claims to 3, 4, and 5, because there we were seeking to get money back in. We were seeking to have those, the amounts that were distributed to Joanne DeRogers that she used to then purchase property that we in our claim there said should not have been distributed out. We were asking that money to come back in.
Mr. Garcia.
Yes, ma'am.
Can you address the argument that was made by Mr. Wallace that you're stuck with the statute of 2020 because that was made in the motion?
Well, first, the Tennyson case from this court, Judge Wallace wrote, indicates that you don't have to plead with that type of specificity. And as Judge Morris points out, we were making a claim saying we're entitled to fees under the derivative statute. The way this came up was actually very interesting. And that is that neither party raised the issue of the applicable statute. We did move under the 2020 statute. At the hearing, Judge Hayworth raises the issue, and discussion then ensued about what was the applicable statute. Okay, and this sort of gets to the waiver argument that we've raised as to they're now saying, well, you can't switch the version of the statute. Because at that hearing, okay, counsel for the appellants said, well, they're essentially the same with respect to attorney's fees. With respect to the substantive right to attorney's fees, they are the same. Okay? He argued, well, the 2017 statute has different notice requirements than the 2020 statute.
And were those notice requirements met here?
No, but that's the point that we raised, is in the affirmative defenses, those were waived. Because the time to make those claims, that this is not, essentially what they're arguing is this was not a proper derivative claim because it wasn't properly pled.
But if they don't know you're proceeding under the 2017, how did they waive that?
Because you look at what we were claiming. It's what we were claiming in there, and then they raised those defenses as part of their affirmative defenses to this claim. So to say they didn't know, why were they asserting the defenses that we didn't give proper notice? We didn't do the things that are required under the statute as to this claim. And the time to make those arguments, Your Honor, would have been a trial for them to stand up and say that they haven't complied with the statute, right? This claim should be dismissed, which is what they argue under the Rappaport case is the appropriate remedy for that. But that's the waiver issue, is whether this is a derivative claim or not. The pleading itself shows the relief being sought is a derivative claim. And they raised defenses regarding derivative claims. And then at trial, and I replied to those. And my reply was, you waive those. Then at trial, they don't bring up any issue. And Judge Hayworth then enters a ruling that says they did for the corporate what the corporation should have done, i.e., they undertook and spent this money. And as Judge Hayworth pointed out, good thing they had the money to do it, to pay for getting rid of a claim against CPI. So while I agree, Judge Smith, we didn't use the magic words, but as the cases indicate, it's not the words you use, it's a relief that you're seeking.
Okay, so after the trial, the motion is filed and the statute cited is 2020.
Correct.
I guess I'm trying to reconcile that with the argument that, you know, they were put on, the motion is supposed to ask for the fees and recite the grounds. And here it did, but it cited the 2020 version.
Right.
Why
So,
does that not preclude you from seeking, awarding fees under the 2017?
because they waived that position. Because if you look at the way
Because
that played out,
Okay,
they waived the switch, as Mr. Wallace calls it, the switch. If you look at the transcripts that are before the court, you have the initial motion that does cite the 2020. We go to the hearing and there's discussion between counsel and Judge Hayworth as to what's the applicable statute. Right? And honestly, there was confusion amongst the lawyers as to what the applicable statute was. Judge Hayworth enters an order and says, okay, you allowed in the 2020, notwithstanding what counsel for the appellant said at that hearing, which he said substantively they're the same. Okay? Judge Hayworth says, no, they're not. Okay? And you have to have an actual recovery of funds. We took issue with that. Okay? But his reading of the statute was a DEC action that eliminates a debt from the corporate records is not a recovery of funds. But in that same order, Judge Hayworth ruled, by the way, these statutes are substantive and therefore they don't apply retroactively, and it's when the cause of action accrued. Okay? So on our motion for rehearing, we said, well, Your Honor, if it's when the cause of action accrues, then the 2017 statute would apply. And that would have been the opportunity in response to the motion for rehearing for the appellants to say, no, you can't do that. You can't switch the statute at this point in time. That was never raised in response to the motion for rehearing. And if you look at the transcript itself, I even raised the issue that I was expecting them to make that kind of argument. I had case law prepared, the Tunnison case in particular, to say you're not necessarily bound by, because you don't need to have the specificity in the motion, which is what Tunnison says. that was never raised. Rather, counsel for the appellants at that hearing basically said, we agree that substantively they're the same with respect to attorney's fees. So never raises the issue of, well, you can't switch the statute on us at this point. So that's where the waiver argument is, because they didn't raise it to the trial court. Where they first raised it to the trial court was in their motion for rehearing that occurred in November of 2021. And there they then say, well, you can't now change the statute, when they didn't raise that on the initial motion for a hearing. What's interesting about that is, although that's raised in their motion, the argument wasn't actually made at the hearing. If you look at the transcript of that particular hearing from November of 2021, that really wasn't, they went back to their old arguments that they had made. They didn't really make that argument, but I will acknowledge they at least raised it in that motion for a hearing. But as the supplemental authority that we cited to the court explains, is that's too late at that point. That's too late to now, because when faced with that issue at the hearing in April of 2021 on the motion for a hearing, that's their opportunity for them to say, no, sorry, you can't do this. So we believe that under one, we sufficiently pled the issues with respect to the demand for attorneys. That's all Caulfield and Stockman require. Is a pleading and replies our pleadings and putting them on notice of attorney's fees, and that we're making demands for attorney's fees. You don't have to specify the statute. Then getting to the issue of the motion, okay, while we did, and the reason why we did is because Judge Hayworth, notwithstanding what the lawyers were arguing, which was the statutes are basically the same substantively as to attorney's fees. I get it, not saying procedurally as to what notice requirements would be required pre-filing the lawsuit. But because that issue was not raised at the time, they waived that argument. And that's why Judge Hayworth went ahead and said, okay, well, I was objecting to using the 2017 statute. Let me apply it to the 2017 statute, because it's very clear the causes of action, and that was my fault. That was my fault in terms of not having done that research before the hearing, because I didn't know it was being an issue that Judge Hayworth raised as to which applicable statute was, and that's when the cause of action accrued. So the cause of action clearly accrued when these debts were first put on the tax returns and books and records of CPI, which the evidence showed ultimately, and Judge Hayworth kind of goes into that in his final judgment, which is really that happened for the 17 tax return, which of course is done in 2018, when all of a sudden this, as we called it, fake debt, they didn't like that term when we used it, but that when this fake debt first appeared on the books and records, which then was increased the following year. So that's when the cause of action accrued. So with respect to the issue of going from the 2020 statute to the 2017 statute, okay, they never objected to us doing that. And in fact, their argument was at the time is it doesn't really matter from an attorney's fee perspective. Okay? So that's why under these circumstances, Your Honor, they did waive that argument that they're now making by not raising it at the time on their initial motion for rehearing. I think it is important kind of to step back a little. And I mentioned it earlier is, and Judge Morris brought it up, and that is the context of this declaratory judgment stage was when there were already pending derivative claims that had been filed under verified initial first amended counterclaim. So those were already in existence at the time as to the derivative nature of the claims. So when this claim is filed, and it is filed with some urgency, I will tell you, because it was set for trial. The case was set for trial fairly shortly thereafter, and yet this issue needed to be addressed. And in part, so the court understands, the derivative claims that were brought in counts 3, 4, and 5, all related to what was revealed in the Pender report. And if you read Judge Hayworth's final judgment, that was a big issue, was a report prepared by an accountant in 2017, the former accountant for CPI, who was brought back in to do this. So the the counts 3, 4, and 5 all related to a debt of $1,085,000 or an amount that had been paid out to Joanne DeRosiers back then. And we took issue with that. And that was all revealed through the Pender report. And so the Pender report also showed the issue of a debt owing. Okay? And that's what the 756 was actually a debt that Mr. Pender said was owed to Joanne DeRosiers going back to unpaid distributions in 2009. Okay? What happened was that report flows forward, and the new accountant for CPI then takes that report and says, well, now there's an additional $756,000 owed to the new owner of this interest.
Mr.
Not Joanne
Garcia, you're out of
DeRosiers,
time,
rather. Excuse me, huh?
You're out of time, sir.
Okay.
If you would just wrap
We
it up.
would respectfully request that in light of the cases, in light of the arguments raised, that Judge Hayworth's well-reasoned order that addressed every one of these issues be affirmed. Thank you.
Thank you. Mr. Wallace, you have 5 minutes.
Thank you, Your Honor. I'm going to pick up with some of the later arguments and then work my way back a little bit. I am going to agree with one thing that Mr. Garcia said. The first time for everything. And that is that there was confusion in the hearings about the grounds for the fees. As I said in my primary argument, we believe they irretrievably committed in their Rule 1.525 motion to the 2020 statute when they made their motion and based it only on the 2020 version. We believe that even if you may not have to be specific, they were specific. And by doing so, committed not just to that as the basis for their fees, but also as the basis for that count, which to that point had not been identified as a claim on anything under anything in particular. But I agree, it was confusing. I remember that from the transcript that Judge Hayworth questioned Mr. Garcia about, well, what is the basis for your fees? And Mr. Garcia's answer is it's unclear which statute it's under. Well, my answer would be it was clear because there's only one grounds in the Rule 1.525 motion. So it's the only grounds they could proceed under. We don't believe we waived anything about bringing up at the switch. For one thing, as I just said, everything was very confusing. Both sets of lawyers were not sure upon the Judge Hayworth's questioning as to what the differences were for purposes of attorney fees between those two statutes. But I don't think that matters because Judge Hayworth decided there is a difference, and it was a material difference. Fees awardable under one, fees not awardable under the other. And most importantly, we gave the trial court an opportunity to fix it in our motion for rehearing before taking this appeal. And the trial court declined to fix that. Now, taking back to some of the other issues, I don't think from the context of of everything we've discussed, that we could be said to have waived issues with regard to moving to dismiss the count 6 as a 2017 derivative action when they didn't decide it was a 2017 derivative action until 6 months after trial. I don't think that makes any sense in a timeline, from a timeline perspective. Waivers of voluntary relinquishment of a known legal right. How are we supposed to know it's a 2017 derivative action claim if they don't know it's a 2017 derivative action claim? So we can't have waived that. And the ultimate result of that is they got fees for something they didn't plead. And that never had to stand up to a motion to dismiss because they never pled it. Back to some of Judge Casanueva's earlier notice questions. It's really the combination of circumstances with count 6 not pled as a derivative action under the 2017 statute, combined with the fact that the reply, I've used the word generic, the reply just says, I want fees on my counterclaim. From our perspective, that tag along at the end of the reply asking for fees could only ask for fees on claims where there is a substantive basis that's apparent in that claim. And we don't believe that that put us on any kind of reasonable notice as to count 6, where there is no claim pled, and certainly not, and I think we all agree now, that certainly they didn't plead the elements of a 2017 derivative action. You know, ultimately, and I just alluded to this a minute ago, is ultimately, well, I'll pick up on something else that Mr. Garcia said, is he said this is a quintessential derivative action. And my point is if this is a quintessential derivative action under the 2017 derivative statute, why wasn't it pled as such? Why wasn't it in the trial memo as such? Why didn't the judge in his final judgment say, well, this is pled as a deck action, but it's really a derivative action? And if it's under the 2017 statute, why did we have to wait till 6 months later to find out that it was under the 2017? Ultimately, the combination of circumstances gave them a bit of the flexibility in how they pled it, gave them a
Wallace,
free
you're out of
pass.
time, sir. Please
Oh,
wind it up.
Then I will wrap up. We ask for reversal of the fees judgment as to entitlement, which would wipe out the entire fees judgment. Thank you.
You guys are great lawyers, both of you. I love seeing you on our docket. Whenever you come, you do a great job in your briefing, your oral arguments. This is an interesting case and you helped us with it a lot and we appreciate it. Have a good day.
Thank you, Your Honor.
Thank
We
you.
are adjourned to deliberate these cases.